Hey, Mike, how do you actually evaluate what a case is worth before you file? Hey, Mike, how do you know when to stop asking questions in a deposition? I feel like I always keep going too long. Hey, I'm Mike Alder, trying cases for 30 years, running a firm, and I get asked questions by lawyers all the time, especially less experienced lawyers that are building their practice. And so today I'm going to answer some of the most common questions. Come on now. Mike, I'm a newer lawyer and I just had my first witness at deposition who answered every question, almost every question, with "I don't know." How do you handle that? Understand that depositions are a much broader thing for relevancy and even a fishing expedition in a deposition that you can't really do in front of a jury with a judge. So in a deposition, when someone says, "I don't know," the rule is there are no rules as to what you can ask. As long as it's not private or privileged information, you could push to get an answer. Are you at fault? I don't know. Why don't you know? What is it that you need to know or learn that would help you answer that question? Are you saying that you have no idea whatsoever? When someone tells me I don't know in a deposition, I push them to either saying that they're just making that up or to identify what it is that they really don't understand. How far away were you from the collision when you first saw the red light? I don't know. Now I want to push them. Well, you say you don't know, but even generally, were you more than a mile away? Well, no. So you do have some idea. Was it more than half a mile? No, it was less than half a mile. Okay. And you used the deposition questioning Socratic method to take an "I don't know," which is likely just a response of "I'm uncomfortable, I don't want to tell you things that might hurt my case or hurt my client or hurt my employer, and I'm going to say I don't know." But under oath, under the penalty of perjury, your job is to push them to get answers. Now, if at the end of the deposition, they've said "I don't know" to almost every question, maybe at trial you do a compendium, especially if they're a party, because you don't even need to call that person as a witness. You can use a party deposition for any purpose at trial. And you say, "Sir, is your memory really terrible? Your Honor, I'd like to play the following video." And it's like, question, I don't know, 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 question. And even that kind of presentation sets the tone for you're not really here to accept responsibility. You're not really here to provide information that is honest and truthful to allow a jury to make a reasonable, fair decision based on the evidence. You're here to try to prevent that jury from getting a full picture by you having a memory that is non-existent. Correct? Mike, are you actually using AI in your practice, or is it still mostly hype? It is not hype in any way, shape, or form. Now, AI is hyped more than anything, right? Every stock that says AI goes up, but AI is here. It is a part of every part of our practice, from analyzing the cases that we may or may not take, to getting values, to organizing the file, to summarizing the information, to strategizing on discovery, to creating documents to interact with the defense about discovery, preparing for deposition, summarizing medical records, creating illustrations, coming up with analogies to use at trial, creating the PowerPoints, et cetera, et cetera, et cetera. I just finished a trial in Paso Robles this last 2.5 weeks. I used AI to prepare the whole thing, to every day going through, getting transcripts, running it through AI, comparing it to the experts that I have prior depots. Have they said this before? What are they going to say in the future? Hey, find me connections between this expert and the lawyers, the defendants, prepare a closing PowerPoint, change the color of the PowerPoint, add this, create an illustration, give me analogies on it's unlimited. And for all of these things, we have created prompts, which in Claude, which we use predominantly, are called a skill, that help us get through different things. And we upload the entire file into a Claude file. And as we were getting transcripts, as we were getting information, I would add it into that same big file. When the defense did their opening statement, we got a transcript of that statement, ran it through Claude that had access to the entire file and said, find us all of the things that he's saying, just like they do with a political speech. Fact check, which is right, which is wrong. Point me to the area where it's right, point me to the area where it's wrong. And it really accelerated my ability to find that information and then use the witnesses to show where the defense lawyer was not representing the cases accurately. So AI is not hype. AI is here. We're happy to help you, show you what we're doing. And it is a constant learning. Get rid of your FOMO because there's always a new product. There's always a bigger, better mousetrap, but learn a mousetrap and just keep at it. Come on now. Mike, what do you actually do the night before a big trial to get your head right? Well, I actually don't work on the trial. I have routines, physical, mental routines. I like jigsaw puzzles. I eat and exercise well and often. I sleep as much as I can. I drink water like a fish because hydration is the number one energy source, sleep source, mental focus source. When I have a headache or I'm tired or I'm in a bad mood, many times a tall glass of water solves that problem. And I have learned this through trial and practice. And so when I go somewhere to do a trial, I bring a big cup that I can see. And every time I see that cup, I know I fill it with water. I have my vitamins. I have my sardines and my food. I have my kettlebell and my rucking sack, and I have my routines written out to help me remember and go over these things so that I can organize my mind and body to prepare for my trial. And now everybody who's tried cases develops their own schedule. My schedule is I get up at 4 a.m. and I work on the trial for what I'm going to do that day from 4 till, in this case, we started at 10 or 10:30. I would work in there, my routines, my coffee, my food, my breakfast, etc. But then at the end of the day at 4:30, with a little bit of exception, I usually don't work on the trial for the rest of the day. I'm doing things to kind of recuperate, work on the other cases in my office, run a business, take care of my family, and then go to sleep as early as I can to get up and reset. Different strokes for different folks. Some people do that work in the evening and then they wake up later. There's no right or wrong way. It is whatever's right or wrong for that individual. So happy to share my schedule. Come on now. Hey, Mike, I lost my first trial. Me too. And I'm still shook up about it. Me too. How do you deal with losing, especially one you thought you had? I guess you had one. Me too. Times 10. Times 100. Welcome to trial work. Welcome to the stress. That is a gift that if you are a trial lawyer and you're able to work through that and get back off of the ground and back on the horse and to deal with that difficult situation and go back for the next client and be fully functioning, that is a gift because it is hard, because it is difficult. And because it's hard and difficult, many people are just not going to want to do it at all. And many people are not going to have the discipline and the courage to do it routinely. I'm still afraid of losing. I'm still afraid of that feeling. I have been lucky. I've done the work, luck, hard work, preparation, experience. You lose. I've been able to win a lot of my cases recently. Before that, I think I lost several in a row. My mentor, the greatest lawyer that I've ever seen in trial, ever, who's trained lawyers that I respect in Los Angeles. A lot of us have gone through that. Some of the best lawyers I've ever met in my life. And my mentor, while I was there 25 years ago, lost 6 trials in a row and then won $3 billion for a single plaintiff. It happens. And so if you're feeling this, let's turn it. Let's turn it from a negative to a positive. It hurts so bad because you care so much. It hurts so bad because you put in the effort and it didn't work out and you're trying to figure it out. That doesn't necessarily mean you do it differently. You learn, but what it does mean is you do it again and you do it again. And so whoever asked this question, understand you are not alone. In fact, I know you're a real trial lawyer because that happens to real trial lawyers on both sides of the aisle all the time. If you want to talk about it, I'm here. Come on now. Hey, Mike, how do you actually evaluate what a case is worth before you file? Well, I would say that I've gotten really much better at evaluating the value of a case because of experience. And, we all have intake departments and, they may spend some time, but because if you've been an experienced lawyer, you can okay, this, here's the range. But with the advent of AI and for us, Claude and Claude Cowork, we've created skills and prompts that aid us in those evaluations. Specifically, we just did one for our employment cases, and we developed criteria of types of cases that we believe have certain values, issues in cases that add or subtract from value, things that we need to see that will allow us to evaluate if we take it or not. And we've run those facts, that a case we don't know about, through our Claude prompt. We have that for a PI case, an employment case, for a premises liability case. Happy to share any of these things. AI is a great tool, but it is not all omnipresent and all-knowing. You use that and you say, let's run that through the context of what the client looks like, how they present. Do I feel like they're telling the truth? Or maybe not. Maybe it lines up on all of the facts, but you just don't have the right feeling. Maybe you're the third lawyer and you would never take a case where you're the third lawyer, et cetera, et cetera. But AI allows you that little quantum leap in at least establishing kind of a base foundation. Happy to share. Come on now. Hey, Mike, how do you know when to stop asking questions in a deposition? I feel like I always keep going too long. Well, let me say this. Your deposition skills are the most important litigation skill, period. In every single case that's litigated, you're going to be taking depositions. And I see a lot of the stress like what you're talking about. When do I stop asking questions? What you're really asking me is, have I asked enough questions to satisfy what I'm going to need at a trial? And that's causing you a lot of stress. But let me add another thing to that. Have I asked enough questions to satisfy what I need at the trial, which is very, 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 very unlikely to actually happen? And so I see this stress of deposition behavior for trials that are 1% going to happen. 99% of the time you're in deposition, you never need that deposition later. And so, of course, you want to get big ticket items. You want to talk about some of the big ticket things on liability or damages to get other information to help you find other avenues of information, names, meetings, etc., things that exist. But it's far better to stop after you've gotten what you think you need. And that is more powerful than trying to continue to gild the lily to protect yourself against something that's very unlikely to happen. And I've told this to a lot of, certainly all the associates when I'm taking a depo and they know the case. And then I'm like, okay, I got no further questions. Like, yeah, but didn't you want to know about whatever? I'm like, we'll find all that out. I'm not worried about not knowing that. But how powerful is it for them to get the feeling on the other side that you just went in, you got what you needed, you're done. There's a lot of power in not asking questions. There's just like in trial. If you've only got a couple of points to make in your redirect, many times it's much better to say, I don't have any other questions. You're telling them they haven't landed a glove on my client. So stress a little less, but I will tell you that what you're doing is exactly what you should be doing. Taking depositions and going through that mental process, have I done enough? Should I do more? Is exactly courage that is needed to be a good litigator. Depos, 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 as early and as often as possible. Come on now.